Now I'm going to hand it over to Todd McGee. Thanks again for joining us, Todd.
Thank you. Let's see if I can get my slideshow going. All right. Thank you, Ken. It's great to be here this morning. When Ken approached me, we talked about several topics for this section in this presentation. And the one thing that I think to start off the year for nonprofits to really put some time into thinking about is reducing risk through good contracts. And I've always found that contracts, everybody pretty much needs to know the fundamentals of contract if you're in business. If you're a lawyer, obviously, but if you're a non-lawyer, you need to understand the role of contracts in mitigating risk. It's just an essential knowledge for anybody in business, especially nonprofits with limited resources. So I'm going to do a presentation on the fundamentals of contracts 101 for nonprofits, and put a special emphasis on an issue that I've had clients come to me about in this post-COVID world. I guess technically we're not post-COVID, but in this COVID world and the post-COVID world is the doctrine of impracticability, which is a defense to contract or enforcement contracts that has come into play over the past year with contracts with the pandemic. When can you be excused for performance of a contract due to the impracticability caused by the pandemic and all the government closures? And also, how do you protect your organization through the use of explicit force majeure or act of God clauses, which is a contract explicit provision that incorporates the doctrine of impracticability. So first off, let me just provide my standard disclosure. This presentation is for educational purposes and is not legal advice. While I am an attorney, I'm not your attorney unless you retain me. The clauses in this presentation are for illustration purposes and should not be used as model clauses for contracts. Each situation is unique, so please seek a lawyer's advice to analyze your particular situation. Okay, that being said, the typical nonprofit contracts that I see, excuse me, are employment contracts, typically for executives, event contracts, grant contracts, leases, affiliation agreements, and insurance contracts. And my favorite type of agreement that I recommend for clients is the affiliation agreements. They're great agreements to have when you are quote unquote partnering with another organization to do something. But I always advise clients to avoid the term partner when you're working with another organization, unless it is in legal terms a true partnership. And the reason is the term partner in the legal sense makes you liable for the acts of other partners. And so if you don't want that, be sure to familiarize yourself with the concept of affiliation agreements, which is the best way to work with another nonprofit in a contractual basis, while also avoiding any sort of connotation of joint and several liability that comes with partnership. So the fundamental questions we're going to go over today is, what is a contract? When do you need a contract? How do you make an enforceable contract? What can you get at, when can you get out of a contract? How has COVID affected contracts? When do contracts have to be in writing? When can you recover without a contract? And what are the most common mistakes nonprofits make with contracts? So first of all, what is a contract? And that may sound like a basic, almost silly question, but it is important to know what is a contract and what is not a contract. The legal definition is an exchange of promises between two or more competent people whereby one person promises to do something in return for something valuable. And if you think about it, a contract really has to do with uh, making promises enforceable, and it has a time element involved, right? If you go into a restaurant, and here we have my version of Oprah Winfrey ordering barbecue. If you go into a restaurant and just order a sandwich, then you give cash or some form of payment, and you receive your sandwich. That's a transaction. That is not a contract. And these type of business transactions go back to bartering during the dawn of time, right? It's when things got more sophisticated where people are not having a transaction where there's a mutual exchange in real time, but rather an element where someone has to promise to do something in the future. That's where you get into the world of contract. So Oprah Winfrey comes into the restaurant and says, I'll pay you $10,000 to cater my party in 2 weeks. Now you have the element of time and you have the element of promises. And to make those promises legally enforceable, we have contracts. So when do you need a contract? Well, you need a contract, I think, primarily for when there's two things at stake. One is when you want to define roles and responsibilities. Oftentimes, I have clients who feel like they don't want to raise the topic of contract because maybe they feel like the other side would feel like they're being too formal, they're being too business-like. Do we really need a contract? I don't want to, insult the other side by, implying that I don't trust them, right? Well, what I tell clients in that case is it's like the Robert Frost poem, where Mending a Wall, where he says, good fences make good neighbors. And that's really what I look at for contracts is if you have a contract in place that defines roles and responsibilities, then everybody knows where the boundary lines are. And so you're mitigating the chance that there's going to be confusion or dispute over those roles and responsibilities in the future. The second reason that I tell clients that when you're contemplating something and you don't know whether you need a contract is think about risk allocation. That's really what a contract does. It allocates risk to the various parties. So do you want to address and mitigate risk with a particular situation? If so, use a contract. It could be the risk of cancellation. It could be the risk of the other party not performing to a certain standard. All these risks can be contemplated and written into a contract and addressed so that you're protected against future losses. Now, if a circumstance is foreseeable and not addressed, then each party bears its own risk. So the courts, when they interpret contracts, they look and they say, well, did the parties contemplate this risk? Was it a foreseeable risk? And if so, did they address it? So if you hire a caterer to cater an event, and you want to make sure that if they don't show up or if they cancel on short notice, then you will be able to seek recovery from them for any damages that flow from that cancellation or that no-show, then you should set forth in the contract, what your remedies would be in that situation. Or at the very least, you want to make sure that there's no limitation of those remedies in the contract. And we'll talk about that in a minute. So courts are going to hold the parties, particularly when they're sophisticated business parties, they're going to presume that they're going to address foreseeable risks in the contract. So how do you make an enforceable contract? Lots of times people get confused about, they have a document that has elements in it that look like a contract, and they may think that it's a contract, but if it doesn't have three essential elements, then it's not going to be enforceable in court. And the first is there has to be an offer. Someone has to make an offer to do something or to sell something, and then there has to be an acceptance that accepts that definite offer. No contingencies or anything. They're accepting that offer as it is made. And lastly, the most important thing is there has to be consideration. And consideration is some form of payment, some quid pro quo exchange where both parties are benefiting. So an offer is a manifestation of assent to enter into a bargain made by the offerer to the offeree, and a conditional on a manifestation of assent in the form of some action, promise, or performance by the offeree. So that's the technical definition of an offer. It has to be definite in its terms. And the offerer is the master of the offer. So the offerer can specify to whom the offer is made. It can specify the means of acceptance by a promise, and it can be revoked by the offer at any time prior to acceptance. Now, acceptance is an action, a promise, or performance by the offeree that creates the contract. It makes the offer's promise enforceable. The acceptance by promise must demonstrate a clear commitment. It cannot be conditional on any act by the offerer, and it must meet the exact terms of the offer, including a means of acceptance. So the power to accept is revoked by a revocation by the offerer, by the death of the offer, by a lapse of the offer, or rejection by the offeree. So here's really the big takeaways from all those legal definitions. First, is there a meeting of the minds? When a court looks to see was there offer and acceptance, it's looking to see are the two parties, did they both have a meeting of the minds? Did they understand what was being offered and what was being accepted, what the payment terms were, what was being promised, et cetera? And if there wasn't that meeting of the minds, then the court is not going to enforce the contract. If the offer is not definite as to its meaning and terms, there can be no contract. One of my favorite cases I ever litigated was a class action against a large for-profit hospital. And they were trying to collect for payments against uninsured patients. And we represented the class of uninsured patients of this hospital. And what they were doing was they were relying upon the little clause when you go into the emergency room and you sign a paper and it says that any charges not covered by my insurance company will be paid by me. And we challenged that, but we said there's no definite price term in there. When patients sign that, they have no idea what the costs are going to be, what the charges are going to be. So there's no contract. And the Supreme Court of Tennessee agreed with us. And so they struck down all those contracts. And so now if you go in Tennessee, if the hospital knows what they're doing based upon that case law, you'll see something in there that says the same language, but then it'll say, if you want an estimate of the charges for your particular procedure, please let us know and we'll provide that to you. So that is a good example of when an offer is not definite and therefore not enforceable. If you want an offer to stay open, then pay for it. If somebody offers to sell you their car for $20,000 and you say, let me think about it overnight, and you come back the next day and want to buy it, but they've already sold it to somebody else, you didn't have an enforceable contract for that, right? You had to offer them something to keep that offer open. So if you paid them $20 and said, keep it, I'll think about it overnight, don't sell the car, and they agree, then you would have a breach of contract in that situation. If you counter an offer, then the first offer is revoked. This often happens in negotiating disputes where somebody says, you owe me $20,000, and the other side says, well, you didn't perform the work very well, I'm not going to pay $20,000. So you negotiate, and then it's whittled down, and the other side says, okay, pay me 15. And then you come back and say, I'll pay 10. Well, with that counter offer, that $15,000 settlement offer that was initially made is off the table. So if they say, no, I'm not going to take $10,000 for this, if you go back and say, okay, well, I'll do the 15 that you offered first, that offer is still not open. It was revoked by the counter offer. If you haven't accepted the exact terms of the offer without any conditions, then there is no contract. So you can't condition the contract on something new. And this is sort of like the counter offer situation. Once you make a change to the terms of the initial offer, the other side has to accept that and essentially make a new offer with those new terms in order for there to be a contract. And once an offer has been accepted, you cannot revoke it. So if you make an offer to sell your car for $20,000 and payment has to be made within 24 hours, that's part of the offer. Then after somebody accepts it and says, I'll accept that offer, I'll buy that car for $20,000 and I'll have you payment within 24 hours. Then the person who made the offer, if they didn't sell the car to them, then they will be in breach of contract and the other party can seek recovery. Consideration is an essential element and is often overlooked in negotiating agreements. Consideration is anything of value that's bargained for in exchange for a promise. It can be money, it could be goods or services. Consideration distinguishes contracts from gratuitous promises and gifts. To be an enforceable contract, each party must receive something of value in exchange for their promises, a quid pro quo. So a good example is a classic case where a young man's grandfather said, if you make straight A's, then I will pay for you to go to any college. The student went and made straight A's and went to his grandfather to pay for his tuition into college. And the grandfather said, no, I didn't really intend to do that. I can't afford to do that now. And the grandson sued him. And the court found that, well, the student performed and got the straight A's that were required. And so you will have to pay for his tuition. And the defense from the grandfather was, well, that's really nothing of value to me. But what the court said is, well, we're not going to question what the parties value in terms of consideration. You are getting something in return of value to you when you made the offer, that is your grandson making straight A's. And so consideration will exist. Oftentimes consideration is the most overlooked element of a agreement, particularly in the nonprofit context. So I'll give you an example. I had a client who has had a long affiliation with another nonprofit. And that the other nonprofit has a program where they raise funds through a particular license plate, and the license plate generates revenue to the nonprofit, and that nonprofit said to my client, "We want you to enter into this agreement that says that you will never do a competing license plate, that all the revenue will be directed to us on this project, and that you will never do an alternative license plate to compete with us." And reviewing that agreement, I told my client, you can't, there's no consideration for this. There's no mutual exchange. If the other side said, "We'll pay you $1,000 if you agree to this," then you'd have an enforceable contract. But they can't impose an obligation upon my client that is just a one-way street. There's no mutuality between those, in that contract, where my client's getting something in exchange for the other nonprofit getting something. So consideration can be a complex issue, and is something that you always should be aware of when you want to enter into an enforceable contract. Okay, so let's talk about defenses to contract. This is situations where you've entered an enforceable contract, but you're looking to be excused from performance, and you can rely upon one of these doctrines, which are defenses to contract. The first is impracticability. That is when an unforeseeable event occurs due to no fault of the party that renders performance impracticable. This doctrine, when it was first developed in the 1800s, was called impossibility, but it has evolved into impracticability to reflect more real-world situations. The pandemic is a great example of impracticability, where a party, due to a government action to shut down certain businesses due to the pandemic, makes it impracticable for contracts to be performed. So a good example is restaurants. Once they, if you had booked a restaurant for an event, and it was shut down due to government regulations of COVID, then the restaurant can be excused for performance because of impracticability. If you're a nonprofit and you put down a deposit for a hotel for a conference, and due to COVID, it is impracticable because hotels are either shut down or there's restrictions as to groups over 10 or anything like that, then you can be excused from performing that contract and seek to have your deposit returned on the defense of impracticability. Now, keep in mind, this is regardless of what the contract says, that these are defenses where the contract doesn't really speak to this particular situation. And so we'll get to the force majeure clause in a minute, which is a particular contractual incorporation of impracticability. These are just defenses where there's no language in the contract at all. Now, it's important with impracticability to understand that these are unforeseeable events. So just like after 9/11, when terrorism was not particularly foreseeable as a risk, after 9/11, terrorism was a foreseeable risk, a reality that should be addressed by contract. And so relying on the doctrine of impracticability post 9/11 for terrorism will be more difficult because it'll be seen as more foreseeable. In the same way, now that COVID, now that a global pandemic is a reality, relying upon the doctrine of impracticability in new contracts in the new COVID and post-COVID world will be more difficult. Frustration of purpose is when a supervening event fundamentally changes the nature of a contract and makes one party's performance worthless to the other. The classic example was an inauguration or coronation of a king back in the early 1900s, where a gentleman rented a room at a hotel to overlook the parade route, but then the king fell ill and the coronation was canceled. And the gentleman who rented the room was able to be excused from paying for that room because it was under contemplation that the reason that he was getting that room was to overlook the parade route. So you can see something similar like that happening with people who've rented rooms in Washington to overlook the parade route for the inauguration for Joe Biden. If that event is canceled or altered, then you may see people looking to cancel hotel reservations under a frustration of purpose argument. A mistake is when there's an erroneous belief that relates to a fact as it exists at the time the contract is made. The classic example is the farmer who makes an agreement to sell a cow to another farmer, not knowing that the cow was pregnant at the time. And therefore, the other farmer was getting essentially 2 cows for the price of 1. Because there was a mistake, an erroneous belief made at the time of contract, then the farmer selling the cow is excused from performance. Misrepresentation is when one party induces a contract by misrepresenting a fact upon which the other party justifiably relies. Incapacity is a defense when one party lacks mental capacity to perform it. So if there is a person who has dementia or some mental disability and they sign a contract to do something and the other side is aware of the incapacity, or if it's someone under the age of 18, then that can be a defense to the contract. Duress is when one party induces the other to contract based upon a serious improper threat. So if someone is seeking to, they hold a loved one hostage and tell someone that, you have to sign this contract, this agreement before I release your loved one, then the other party can get out under duress. Similar threats or blackmail, threat of physical harm, anything like that. Undue influence is when a person is affected by some weakness or infirmity and enters a contract due to improper persuasion from a person in a special position to assert it. So the classic example is a nurse who is taking care of a elderly patient and is able to assert undue influence to have that patient enter a contract giving her some benefits. Public policy is when the contract involves an immoral act that does not warrant judicial enforcement. So, paying hush money, a politician paying hush money to someone in exchange for a confidential agreement not to disclose that they had some adulterous affair. Could be that confidentiality could be voided under a public policy argument. And then ambiguity, when there's a term and issue that can be interpreted in different ways, then you can have the court, you can argue that the court must interpret that in the favor of the party who did not draft it. So if I contract with another party that says that I will provide legal services and will use all reasonable efforts to deliver services in a timely manner, and the other side wants to sue me for a breach of contract because they haven't received those services within a year, then the court could say, well, that's an ambiguous term. It was drafted by me, and can seek to interpret that term against my interest as the drafter of the contract because it was ambiguous. So impracticability in times of COVID. The key to impracticability is arguing that if you're seeking to enforce this as a defense, is that performance has been made excessively burdensome, impracticable, not necessarily impossible, by the supervening event. The event, in order to assert impracticability, must not have been caused by the party seeking to be excused. So in the event of COVID, certainly there is not any basis for anyone to argue that the COVID pandemic and the resulting government regulations were caused by the party seeking to be excused. The event must be inconsistent with the basic assumption of the parties at the time the contract was made. So in terms of COVID, there was no basis to assume that a pandemic was forthcoming. But as time goes by and the contract is made with notice now that COVID has reached American shores and it was going to be a widespread burden on the economy, then if you seek to excuse performance, then the other side could say, well, no, it was a basic assumption when the parties made the contract that we were in a global pandemic. And so you can't seek to excuse performance when COVID was under the contemplation of the parties. The supervening event must be, in some sense, unforeseeable, but not inconceivable, in the sense that it must have been so unlikely to occur that a reasonable party would have not guarded against it in the contract. So again, this goes to the issue of foreseeability. If a court says that this event was foreseeable, then you're not going to be excused under impracticability. And the party seeking to be excused of its obligation to perform must not have expressly or impliedly agreed to perform despite the event, and that it did not assume the risk of it. This element is often an issue in instances of hurricane damage, that when a business is seeking to excuse performance under contract due to impracticability, but there's evidence submitted in trial that it sought insurance for business interruption due to hurricanes, then the other party can say, look, you got this insurance in order to protect against this risk. So that is an element that they can argue in saying that you cannot rely upon impracticability. So when you're looking at protecting by contract for things like COVID or terrorism, it's the force majeure clause that comes into play. And a force majeure clause is essentially defining impracticability within the contract itself. So instead of having to rely upon this defense of impracticability, a force majeure clause brings it within the four walls of the contract, so to speak, so the parties can articulate and agree upon what would constitute impracticability, and thereby protect against uncommon but not unforeseeable risks. So moving forward, um, in this time of COVID, what I've advised clients is if you're seeking to be excused from performance of a contract due to COVID, then you need to look at your current agreement. What does the language say in the force majeure clause? I have found that most are broad enough to include a pandemic. For instance, it'll have language that says, if if performance is impracticable or impossible due to governmental regulation or governmental closures, and it'll have a catch-all that says that if it is impossible to form due to reasons beyond the control of either party. All these things are broad enough to fall under pandemic. And really, the reason that it is so broad is because parties like hotels and event spaces, they wanted that protection, right? They wanted to be able to say, look, if we have to host a huge conference, but the government shuts down our hotel for whatever reason, due to anything under contemplation that the government could take that action, then we don't want to have to be bound by the contract either. So it's been my experience that that I've been able to assert successfully on behalf of clients of using this language, which was drafted by the hotels or the event spaces themselves, and saying, no, you included this broad language. You can't wiggle out of it now. So my client is excused from paying you a cancellation fee or paying you for having a conference at your hotel because of the language that you drafted. And here again, going back to the ambiguity doctrine, the doctrine of ambiguity that courts look at with contracts, because the hotel and event space were the ones who drafted this language, which included governmental regulation or the catch-all impossible to perform due to reasons beyond the control of either party, then the court's going to interpret that against the interests of the hotel. That's what the doctrine of ambiguity is supposed to do. So I've advised clients, look at your agreements, see what the language is. It's probably broad enough to excuse your performance under the terms of the contract. Now, for new agreements, you should include specific language, such as pandemic, disease outbreaks, governmental closures, explicitly in the definition of force majeure. Again, going back to 9/11, you saw after 9/11 that terrorism and terrorist acts were included within force majeure contracts. And so on a go-forward basis, you're going to see that these terms are included in force majeure, and you need to include it in your force majeure contracts. Now, be aware that a superseding event will only excuse performance for the period of impracticability. So if you have a week-long conference and it looks like that the government will have closures for one day out of the week, then the hotel could argue, well, the other 6 days, you're not excused from performance because there is no restriction for those 6 days. You must demonstrate diligence and good faith in trying to overcome the event. So if there's something that you can do to still perform, then the other side can say, well, look, you can have your conference and it'll be within the restrictions of the government as long as everybody wears masks and everybody sit 6 feet apart. And if that's doable, then the other side can say, well, you're not allowed to be excused under the force majeure clause because you haven't tried in good faith to overcome this event with us. And also be aware that courts will always err on the side of not excusing performance. So it's going to be on it's going to be the burden of the party seeking to not perform to convince and persuade the court that it should let it out of performing the contract. All right, so when must a contract be in writing? You can have verbal or oral contracts as long as the elements of offer, acceptance, and consideration are in existence. There is a ancient law called the Statute of Frauds that all states have adopted that says the exception to that general rule are when there are interests in land, including leases over a year, then that has to be in writing. Any contract when it will take longer than a year to complete. So if you're going to hire an independent contractor and they are going to work for 13 months to complete a project or assignment, then that needs to be, the contract needs to be in writing in order to be enforceable. Marriage interests, which really shouldn't come into play with nonprofits, any surety interests where you're assuming an obligation for someone else's liability, and then any sale of goods over $500 needs to have a written contract in order to be an enforceable contract. When can you recover without a contract? The doctrine of quasi-contract or unjust enrichment states that a person who is unjustly enriched at the expense of another is required to make restitution. So think back to that lawsuit I talked about earlier, where all the patients who were uninsured, who signed the admissions document that they would be responsible for any charges not covered by their insurance. The Supreme Court of Tennessee said that's an unenforceable contract, so no contract exists. Well, does that mean that the patients got free health care for nothing? That would be a windfall. And so the hospital could argue in that situation that, hey, we may not have a contract, but we're entitled to restitution to receive the reasonable value of the services we provided to them. Otherwise, these patients would be unjustly enriched. The hospital could have done that if they wanted to. They would have had to go in front of a jury and argue that the reasonable value of services for an MRI was, $1,000. But they didn't want to do that. They just dropped the whole thing because we all know how complicated it is with different charges for insured and uninsured patients. And so they just dropped it. But they could have if they wanted to under the doctrine of unjust enrichment. So if you ever enter into an agreement with another party, and you confer benefits upon them, and then they look and they say, well, actually, this is not an enforceable contract, and the court says, that's true, this is not an enforceable contract, you still have this means of recovery under quasi-contract unjust enrichment. All right, other issues. This is one of my favorite topics for nonprofits because I see it all the time. Agreements to agree, memorandums of understanding, memorandums of agreement, letters of intent. these are all documents that I see all the time in the nonprofit world, which either are contracts when the parties or one of the parties didn't intend for it to be a contract, or it's used appropriately to be something less than a contract, but is still a useful document for the parties. So what I like to call these documents are memorandums of understanding, because when you use the term memorandum of agreement, agreement is within the name of it, and that implies that you have a legal enforceable agreement or a contract. But memorandums of understanding are great tools when you want to document understandings that you want to memorialize without making a binding contract. So if you're going to do a collaboration with a for-profit business who wants to do an event that will benefit your nonprofit with donations, and so they're going to have that event at their space, and it'll be on the weekend, and people will come, and people can donate to your organization at that time. That's something that you very well may want to memorialize all that happening. This event will happen on Saturday, September 27th from 9 a.m. to 3 p.m. And we'll have people there representing the nonprofit. We'll do a 15-minute presentation and accept donations, et cetera, et cetera. But so you want all that understood in order to have a good relationship with this for-profit business that is wanting to support your organization, but you don't want to create legal risk by having a binding contract. So if something happens and you can't be there to make your presentation or whatnot, then you don't want to have any sort of legal liability for failing to appear or whatnot. So MOUs are great for nonprofits where you say, we don't want the legal risk if anything goes wrong, but we want to make sure that all the parties understand the boundaries of this event and our participation in it. MOUs are also great tools when you want to enter into an engagement with a party instead of a marriage. So this kind of comes when there's complex transactions being contemplated, and you kind of have essential terms understood between the parties, but you're still negotiating the details of the transaction. So, and the other party says, well, we really need to, in order for us to proceed and put all this time and effort and expense into negotiating the details, we really need something to show that you're committed to this transaction. And so an MOU is good in that regard, because you're essentially getting engaged to that person, but not married to them yet, vis-a-vis a contract. So an MOU will, what I recommend is it'll state the parties agree to act in good faith to enter into a binding agreement by such and such date with the following essential terms. So you can lay out those essential terms to give comfort to all involved that these are what we understand the agreement will have. But your legal obligation is really to only act in good faith at that point to try to enter into a binding agreement by a later date. So if it falls through, as long as you act in good faith in negotiating, then you can pull out of that without having any legal liability. So those are the two purposes of MOUs that I see most often. But be careful. If a written document contains offer, acceptance, consideration, then it can be a binding agreement no matter what you call it. So I often see documents that are called MOUs, memorandums of understanding, that have all the elements of contract, but for whatever reason, it was called an MOU. A court doesn't care what the document says at the top of the paper. What it looks for are the three elements of contract. Was there an offer? Was it accepted? And was there consideration that existed for that? So when you're negotiating an agreement, it's always helpful to get a good lawyer. I know that's a self-serving statement, but you don't know what you don't know when it comes to contracts, unless it's a transaction that you've done many times, and you have a good form contract, and there's nothing unusual in this particular instance. You're going to want to have a good lawyer to advise you on the details. If there are any changes made to a contract, you must make sure that they're initialed and dated. So you come up with the contract, you're all around a table, and you want to make a change to a certain detail. It's fine to mark through the clause and change it by handwriting and have it initialed and dated to reflect that it was made at the time of contract. If you don't understand a clause, then rewrite it. I've seen many times of clients of all types when there's a dispute as to a particular clause in a contract, and it's clear in talking to my client that they really didn't understand the clause. Well, if you don't understand the clause, ask for it to be rewritten in an understandable fashion. No outside understandings will be enforceable to a contract. So everything that you want should be reflected within the four corners of the contract. Ask for what you want in the agreement. Don't be shy. There is no such thing as a boilerplate form contract. All contracts are open to negotiation, so ask for what you want. If there's anything in a contract that's inapplicable, then strike through it and initial it and date it. Make sure the other side does too. You don't want to have language in a contract that has nothing to do with a particular transaction. Avoiding the most common mistakes. These are the 4 C's of what I call the 4 C's of contract that most often, if you follow these rules, you'll avoid the most common mistakes. First, does the contract contain clear language and detailed terms so each party understands its rights and obligations? Is it consistent? Is there a contradiction within the document that creates an inconsistency? In one section, does the contract say party A is going to provide insurance, and in another section it says party B is going to provide the insurance? Make sure there's consistency. Contingencies. Are there any contingencies where something must happen before a contract takes effect? You have to understand if that exists in the contract. And then consideration. Is each party receiving something new of value in exchange for the agreement? I'm going to go through these because I'm running out of time and move on to specific terms and clauses for you to know. These are kind of boilerplate clauses that you see in lots of contracts, and people will often just kind of glaze over them because they look so legalistic. But remember, there's no such thing as a form contract. There's no such thing as boilerplate language. Everything is open to revision. Make sure you understand everything, including these legalistic clauses. The whereas clause at the beginning of a contract, not all contracts have them, but basically the purpose of the whereas clause is to set the table for the contract. You know, it's the clarity of the contract. So oftentimes it's very useful so that if someone has to interpret the contract, you know, years down the road, if it has whereas clauses in it, that set forth these provisions. It will help the interpreter, whether it's a court, an arbitrator, a mediator, they'll understand provide a frame of reference for the agreement. So in this case, We Love Animals is a nonprofit in Nashville. Jane Smith is a contractor, is a professional consultant and website provider and designer, and they desire to enter into an agreement where contractor will provide website hosting and consulting services on the terms and for the consideration set forth below. So now you know what this agreement is all about. Definitions are critical in complex agreements to make sure that key terms are understood. So make sure that the key definitions are clearly stated in the agreement. Insurance is a critical element anytime that there is any potential for liability. And it can be a complex transaction or it can be a simple transaction. I often tell people one of the most riskiest transactions that you can engage in as a business is to have somebody come if you're responsible for trimming trees on property. It may be a small dollar contract, but it has a lot of risk involved. And so you want to make sure that there's insurance in place to protect you in the event that you have a problem that results in injury to someone on the property. So in this instance, the contractor will furnish general liability insurance with at least $1 million in coverage, $3 million in the aggregate. Organization shall be listed as an additional insured of said insurance policy. At the request of contractor, contractor shall provide a certificate of insurance evincing said coverage. Additional insured is a key term to know. It allows party A to make a claim on party B's insurance for losses caused by party B. So let's say that you hire a caterer to do an event and they give everybody food poisoning. Well, if you're an additional insured, you can make a direct claim on the insurance policy for the loss caused by party B. And so that's a big benefit. You don't have to go through party B to receive that insurance. You can go directly to the insurance company and say, I'm making a claim for these losses. They were caused by the caterer who gave everybody food poisoning. Now, an additional named insured is a little different. It allows party A to make a claim on party B's insurance for any loss. Let's say that you have a tree trimmer come to take down some trees on your property. If you're an additional named insured and there's something that you do or one of your employees does that results in the tree trimmer trimming trees that causes damage to someone, then you as party A, even though your negligence of your employees or your agents contributed to the loss, you can still make a claim directly on party B's insurance. It's rarely used, but that's the big difference between additional named insured and additional insured. And then certificates of insurance are documents that are issued by parties insurance carrier, evincing coverage and listing any additional insureds or additional named insureds. Identification is critical when you want to shift the risk to a party. So in this case, contractor agrees to identify, defend, and hold harmless organization from and against any liability, damages, and costs. Organization may owe or suffer to any third party as a result of the gross negligence or intentional acts or omissions of contractor in the performance of his or her duties hereunder. The critical elements in this are first, You want to have indemnify, defend, and hold harmless in these agreements because they're each distinct things. Indemnify means that they're going to pay any losses for that you incur as a result of their negligence. So if you're sued by a third party, say someone who's at your event got food poisoning and you have indemnity in place, then when there's a judgment rendered against you in court, then this indemnity will kick in and the caterer will pay your judgment. Defend means the caterer will step in and pay all your attorney's fees and provide you with an attorney to defend you in the lawsuit. Hold harmless means that they will not point the finger at you for causing any of the damages, and also instead of reimbursing you for the judgment, they will pay your expenses as they're incurred and not waiting until the end to see the judgment that goes down. You'll notice that I use the term gross negligence in this indemnification. You do not want things to be limited to gross negligence. You want simple negligence in your indemnity clauses. Gross negligence is a very high standard and it can undermine the effectiveness of indemnification altogether. So you need to be aware of that as well. Limitation of liability is when any damage awarded against contractor for breach of this agreement shall be limited to the total compensation set forth in this agreement, less any amounts the contractor has already received. In no event shall contractor be liable for lost profits, consequential, or incidental damages. So if you have a caterer and they have this clause in their agreement, then you could be in trouble if you suffer damages because you don't receive the hundreds of thousands of dollars in donations that you anticipated because everybody got food poisoning. Well, if they have a limitation of liability clause in their contract, then the only thing that you can recover from them is any costs, any charges that you already paid them. So if you paid them $100,000 to cater the event, the food poisoning happens, you suffer damages due to lost donations, your total recovery is limited to that $100,000 that you paid them. Arbitration, I think everybody's familiar with arbitration clauses. They can be a good thing to get quick resolution to claims without going to court. It's just on a case-by-case basis if you want to have those. Attorney's fees, the prevailing party of any legal action conducted under this section shall be entitled to recover the reasonable fees and expenses, including attorney's fees that incurred as a result of legal action. You want to have attorney's fees in your contracts because the economics of litigation are so bad that if there's not an attorney's fee provision, then your attorney's fees can easily eclipse any recovery that you have. So you want to have attorney's fees in your agreements to make sure that that does not happen. Choice of venue or law, you want to have at all times possible Tennessee law apply to your contracts, and most importantly for venues to be in Nashville, Tennessee, so that you don't have to travel to New York or California or something in the event of litigation. Assignment. Assignment is when someone who you contract with can turn around and have someone else perform in their place. So in this case, contractor may not assign his or her rights or obligations under this agreement without organization's written consent. So if you hire a caterer for an event and you want to make sure that that caterer is the one who does the catering and doesn't turn around and subcontract it to somebody else, then make sure you have an assignment clause. Evergreen clauses are automatic renewal clauses. In this case, this agreement shall renew automatically for an additional 1-year term unless the party provides written notice of non-renewal to the other party at least 60 days prior to the expiration of the current term. So oftentimes I see clients who forget that this is in the contract and they have subscribed for a year or more with some service provider, and they have a horrible experience, but they forget to provide notice of non-renewal. So they're stuck for another term. So it's always good to be aware of these clauses and to make sure that someone in your organization is responsible for knowing when these things come up for notice. Termination, make sure that you have good rights of termination. Know that if you can terminate without cause or for cause. If it's for cause, make sure the cause is clearly defined within the terms of the contract. And then lastly, entire agreement. Entire agreement means that that when you agree to this, then you're saying that this agreement constitutes the entire agreement of the parties with respect to the subject matter hereof. So if you have other agreements with a party and you sign this contract with this clause, then that conceptually could mean that they could argue that the other contracts are superseded by this contract. So just be wary of that when you have an entire agreement clause. It also means that any prior emails, conversations, etc., between the parties prior to entering into the agreement are now inadmissible. The parties have to rely upon the four corners of the agreement, and by saying that this is the entire agreement, then that other evidence that was discussed outside of the contract is inadmissible. And Ken, that's it. That's a lot to cover in an hour. I hope I didn't rush too much. If anybody ever wants to contact me, I'm available at tmckee@tmckeelaw.com. Always happy to answer any follow-up questions. Ken, did you have any questions?
Todd, I don't, and but thank you for presenting today, and I think there were lots of good points and good takeaways for nonprofit organizations to be thinking about as they enter into contracts, particularly to your point, in a time where we're dealing with a pandemic and the coronavirus, where things are being canceled. So I think all of those are helpful points.
And I will just add, Ken, that everybody knows, since everyone's nonprofit on here, I generally don't charge. If people have questions, simple questions that they just want to call up and bounce off me, again, I'm always careful not to, venture into giving advice for people who aren't clients. But that being said, if you have a simple question and want to call and kind of discuss it, I'm happy to talk to folks. I generally don't start charging until it gets down to really substantive legal advice.
Okay, are you all seeing the, Fran, if you could chime in, do you see the correct thing shared on the screen here?
Looks
Yes,
good,
you
Ken.
are. You're right,
Okay,
Ken.
okay, good deal. So a little wonky Zoom action there, but so thanks for your patience. So Sean and I are going to briefly cover some nonprofit accounting and reporting topics. Some of these topics, revenue recognition in particular, we covered in our previous session that we did with you all in the spring. And so today, while you have the content in your slides, it is something where I'm just going to hit a couple of high points or trouble spots related to revenue recognition. So again, more information than what we're going to cover today. So we'll go ahead and talk about what we'll see. Just that these are the topics that we'll cover. So a couple of notes on PPP forgiveness accounting, specifically accounting considerations. The AICPA issued a technical practice aid or a technical Q&A in the mid-2020 that talked about PPP loans being able to be treated either as a loan, where you'd recognize the forgiveness when it's been legally released. You get a document from your bank saying that that you were released from obligation. Or there's a second option, that if the nonprofit expects to meet the PPP forgiveness and chooses to do so, that you could treat this as a conditional contribution. One quick point just to remember as well, from a single audit perspective, remember that your PPP loans will not go on your schedule of federal awards, but if you have other nonprofit grants that are governmental grants, you do need to consider any other stimulus package considerations or funding that you receive on your schedule of federal awards. So, but not the PPP specifically. So now looking at the accounting considerations for conditional contributions, just a reminder that if you do take this conditional contribution treatment and you've got a June 30 year end, we've covered this territory with some of you all already. We see most organizations treating this as a loan, where you'd actually recognize the forgiveness when you get the document from your bank. And so it's likely on your books at June 30th as a loan. However, if you have a December year end, you haven't applied for forgiveness just yet, you have some choices here as to whether or not you'd recognize this as a conditional contribution, where you might have this liability off your books, or if you've not received the forgiveness document from your bank or applied for forgiveness, that you have the opportunity to recognize it as a loan, and maybe in your 2021 year end have the revenue recognized. So, a couple of treatment options there to be thinking about. So revenue recognition, a couple of brief points. I am going to move to slide 7, or actually slide 8. So really this this flow chart provides, just a question and answer thing to see whether you're going to apply exchange transaction guidance to any transaction, or whether you have a contribution and how you step through that. So this new standard really clarifies some of the existing standards on how to treat grants and contributions. One of the fundamental problems that we've had a lot of conversation with clients about, and so something to keep in mind, is whether the resource provider is receiving benefits. So in other words, you have an exchange between two parties. And if you have exchange transaction treatment, your resource provider is receiving benefits in return for your grant, then you're actually applying revenue recognition, traditional exchange transaction guidance. So something to keep in mind. If you have if the benefit is really going out to the general public, the general good, that is actually a contribution treatment. So that's something that when you look at grant agreements that you're receiving from different funders, who is actually receiving the benefit? Is it your foundation that gave you the money, or is it the general public? And if it's the general public, this is a contribution. So that's been a trouble spot. Another item that I think is important from a clarification standpoint is, if you do have a contribution, determining whether that contribution is conditional or unconditional. So if you have a conditional contribution, you recognize that contribution when that condition's been met. In other words, it might sit in deferred revenue if you've got money in advance, but it's still a contribution that you typically recognize when you are promised the contribution. So again, a conditional contribution, if you have a right of return that's inherent in your grant agreement, that's certainly one thing. Where there's been more confusion as to whether or not there's a barrier that you must overcome to be entitled to the funds. And so a couple of words about barriers for contributions and grants. If a barrier exists, there could be a measurable performance obligation, like you've got a specific level of service, number of people served, maybe a matching requirement. We'll give you $10,000 if you raise another $10,000. You've got something that you have to do that's measurable in that grant agreement. Or you could have something like it's a stipulation limiting the discretion by the participant on how to spend the money. It's not just, we want you to use this for XYZ program. We want you to hire certain staff, spend a certain amount of money on this type of expense. A lot of times federal grants are going to have contribution treatment, but they're conditional contributions because there's quite a few stipulations in those grant agreements on exactly how you're going to spend that money. There's qualifying expenses, specific protocols that you follow, things like that. So that is something to keep in mind, something that we've had a lot of conversation about as we've implemented this new standard on contributions and grants. Now to revenue recognition. These are for exchange transactions. And oh, by the way, in your materials, you'll see some examples. We're not going to cover those today. So revenue recognition. Now I'm on slide 20, if you're following along. The implementation of this new revenue recognition standard, because of the coronavirus pandemic, there's actually been a deferral where you can actually have an additional year to implement this. And so some organizations that are on this call today have already implemented. Some have deferred to their next fiscal year, and so that was allowed with a change that happened in the spring due to the coronavirus pandemic. So just certainly keep that in mind. Not a lot to mention in terms of trouble spots, even though this is a pretty pretty robust standard. One of the probably one of the key things that we've had conversations about is identifying performance obligations in a particular contract. So a couple of examples: memberships. If you have memberships with people, like if you've got a museum or something that requires an admission price, there could be some other benefits that will need to be broken out in that membership cost. So you're looking at the different exchange elements that are in there. Another item is sponsorships that include multiple elements. So you could have a sponsorship where not only is there a contribution element, you apply the contribution guidance to that element, but you might also have an exchange element in there as well. Tickets to a dinner event, free admission to your site for 50 people, etc. So you need to break down those sponsorship agreements and assign value to each element. So I think this is one of the more complicated pieces of the new revenue recognition standard. And so just be on the lookout for that. We'll be happy to talk with you and assist in that process. Again, told you revenue recognition would be brief. That's brief. There are a couple of new standards that are on the horizon for nonprofit organizations that we want to just make you aware of. Contributed non-financial assets is the first one. So what's a contributed non-financial assets? Fixed assets, real estate, your office space, if that's contributed office space for you. Supplies, food, clothing, pharmaceuticals, other things like that, donated goods, or professional services. So what this new standard is calling for is greater clarity and disclosure about non-financial asset contributions. So looking at the next slide, I'm on slide 39. You'll have footnote disclosures that will now be required that are enhanced from what's been done in the past. So the footnote disclosure will have a policy on liquidating or using your non-financial assets. So for example, if you have contributed office space, you're using that asset. But if you have contributed food or clothing and you distribute that food or clothing to your constituents, then you're actually using or distributing those non-financial assets. And so there's a footnote disclosure that will be required that talks about how you do that. You also have a disclosure on valuation methods used to value the goods and services that are contributed. One quick note about the valuation: there's no change in what the previous guidance is on valuation. And the previous guidance, the current guidance, is that you use the principal or most advantageous market for goods or services that require an entity to use so you're using the most advantageous market is the key point here. if you have contributed pharmaceuticals and you're distributing them to underprivileged areas, something like that, obviously you're not going to collect on the value of those pharmaceuticals, but you do value them at their most advantageous market on your books, and then you'd have a distribution of that at the most advantageous market price. So again, just some further disclosures on in-kind goods and services. So definition of collections, another new standard, very simple here, but there's just a clarification that an organization can use proceeds from the sale of collection items that can be used to acquire other collection items, that's the same, or to support, this is the new part, to support the direct care of existing collection items. So an important distinction there. So with that, I am going to turn it over to Sean to talk about leases. Sean?
Thank you, Ken. Ken, can you see my presentation? Okay.
You're good.
All right, I'll get started. So first off, thanks again for attending today. Again, this will be a crash course in leases, very brief. We're trying to get Fran to have as much time possible as to talk about the new tax updates. So, all right, let's see here. The new lease standard. So the new lease guidance originally came out in 2014. Several follow-ups and clarifications were issued on this topic during 2019. 1 year delay was approved, and then of course the additional 1 year delay due to COVID came into play. It's now effective for fiscal years beginning after December 15th, 2021. So in layman's terms, if you're a calendar year end entity, it will be effective for your December 31st, 2022 financial statements. This is assuming you're a non-SEC company. If you're a private or an organization. So, and if you are like a June 30th year end, it won't be applicable until June 30th of 2023. So under the new guidance, an organization will be required to recognize assets and liabilities for leases with terms of more than 12 months. So the big change in short is operating leases are now going on the balance sheet. Historically, capital leases were already on there. There's a new term for capital leases. It'll be finance leases under this new guidance, but the big change is operating leases are going to be going on there. All right, so next slide. So right of use asset and liabilities will be presented on the statement of financial position for all leases over 12 months in duration. So the standard is silent on setting a capitalization threshold, but we would recommend that you do set a capitalization threshold and just make sure you disclose it for, maybe you've got a 4 or 5 year lease, but it's really only $1,000 a year. So you can set a capitalization threshold of $5,000 to exclude that. So the other key is no reassessment of existing leases when you implement this unless they are subsequently modified. So what I'm saying in gist on that is if it was an operating lease beforehand, it's an operating lease when you implement the new standard. If it was a capital lease beforehand, you'll be just calling it a finance lease under the new standard. So current GAAP requires measurement and classification to be assessed at inception and recognition at the commencement of the lease. So under the new guidance, will require measurement, classification, and recognition at the commencement of the lease. That's one of the big changes on it. So what is the commencement date? Commencement date is the date at which a number of important determinations and measurements are made related to the lease, such as lease term, lease classification, and lease payments. So the lease commences on the date that the lessor makes the underlying asset available to the lessee for use. So when you are able to use that asset, that is the commencement date. It is not the date that you make your first lease payment. So you'll be using a discount rate. So you'll be taking these future lease payments and you'll be discounting them back to present value when you put them on the balance sheet for the first time. So you'll use the rate that it's implicit in the lease unless unable to determine that. And under that method, then you would either use a secured borrowing rate or private companies may elect to use a risk-free discount rate. So changes to the financial statement presentation. So the big change obviously is going to be operating leases. So operating leases, you'll have a related asset is shown as an operating lease asset on the balance sheet or statement of financial position. And you'll have a liability shown down the liability section. You'll have two different ones. You'll have the current portion and the non-current portion. So for finance leases, which were formerly capital leases, so the asset is shown where they have historically been classified, which in most instances will be PP&E. You know, historically, if you capitalize a server or something along those lines, you already had it in PP&E anyway. So that's where the asset will be, where it always has been. But there will be a separate liability shown as a financing lease, breaking out the current and non-current portions. So on the statement of activities impact, your income statement impact. So finance leases, amortization expense is recorded as assets are amortized and interest expense is recorded. So finance leases, you'll have two separate items showing up on your P&L. So operating leases, the lease expense is recorded on a straight line basis. So there is an interest component, but it's only going to show up as rent expense on your income statement. So that's a little bit blurry, this presentation on this, but as you can see here, operating leases down the asset section, you can see where that is. Your capital leases, or aka finance leases now, would be in the property and equipment line item. The operating lease would be where the new operating leases are. The liability section, you can see you've got a current operating lease liability and a current portion of the finance leases. And then you've also got the corresponding non-current operating lease and the long-term financing lease pieces. So that's pretty much it. That's a quick summary of it. Now, I will say this, we didn't go into all the details on, there is a slight change between capital leases to financing leases. Historically, you know, if you've been doing this for years, you know, there was the 75%, the 90% rules, those have gotten tweaked. So that when you go to implement, there will be a little bit new nuances when it comes to that, but we've got plenty of time to get this implemented, and we'll be discussing these in future seminars. We'll discuss them again probably this fall or next spring as it's getting closer to the due date on this. So if there's not any other questions, I'll turn it over to Fran.
All right, thank you, Sean. And as Fran gets ready to start, I'll go ahead and give you all the second word if you're here for CPE credit. I want to make sure you get that. So the second word is standards. Standards. So we just learned about some of the new accounting standards that are on the way to us. So
Sean, can you stop sharing? Oh, there you go.
Great. And so now we'll turn it over to Fran. Thank you, Fran.
Okay. Is that showing up right, Ken?
You're good.
Okay. So for the next 2 hours, I'm going to talk about the stimulus package. Oh, wait, I only have 30 minutes. So it's going to be pretty fast. This is the $900 billion stimulus package that was signed into law on the 27th of December. So we have been struggling again this year. We set this date back when there was just a few things, tax things to talk about. And then all of a sudden, bam, everything changed on the presentation. So the Consolidated Appropriations Act, it's another round of PPP for the hardest hit people, and also obligation for new people to get it, an opportunity for new people to get the PPP. So we're going to go over quickly how to calculate who's eligible, a little bit about forgiveness for both the PPP1 and PPP2, and then we're going to hit the employee retention credit, which is, it's a big change in that on the Consolidation Appropriations Act. And then a few other provisions. And then maybe we might have time to talk a little bit about what I was going to talk about anyway. So the timeline. Okay, so this happened on the 27th of December. And then we just are getting guidance. So last week, the Treasury issued some IFRs, some interim financial guidance. And then on the 8th of January, the SBA has issued their form for the application. So the first draw form, if you were newly eligible, your first draw form is a 2483, I think. And then the second draw is the same number, 2483 SD, second draw. So that's if you did get the PPP last year in 2020. Additional guidance, it's coming out every day. The places I look is the AICPA on Twitter. They do tweet things that are coming out and give links to other things. So if you feel like you're lost, that might be something. Go to AICPA COVID, go to Craft COVID. So there are a lot of places out there that have a lot of information and it's changing daily. Okay, oops, let's see. Okay, PPP. So if you got the first draw last year and now it's your second draw, this is for those hardest hit entities. So the maximum loan amount is $2 million, eligible business for 300 FTEs or fewer. You must show that you had a 25% gross receipts decline in any quarter 2020 as compared to the same quarter in 2019. And yes, you're looking at 2021, but they don't want to get to the second quarter of 2021 and try to compare that to 2020 because they both might be bad. So that's why they're looking to 2019. You will, for your second draw, you will have used or will use all of the first PPP. So you don't have to have forgiveness. In fact, if you've already done forgiveness, that's not a good thing a lot of times. And also, if you weren't in operation in 2019, then you've got a different calculation. And we just do not have the time to go over that right now. Okay, if this is your first draw, these are some of the businesses that can get it for the first time. Businesses with 500 or fewer employees that are eligible for some other SBA loans, nonprofits, including churches, some sole proprietorships, independent contractors, self-employed. And the big thing that is for this audience is 501c6s and news organizations if they have fewer than 300 employees. Now, also that is employee at that location. So there are some caveats that you can have 2 locations and have more than 300 employees. Okay, the last date to apply for this is March 31st, 2021. And also for the second draw PPP, and we're calling it a PPP2, that is also the last day that you can apply for this. Okay, for the 501c6 organizations, which this is really applicable for, you have to have the 300 or fewer employees, and you are subject to lobbying thresholds of 15% of receipts, 15% of activities, or $1 million. And that might be an and it also, I mean, it's pretty limiting on some of the organizations. So if your organization is a C6 and you do a lot of lobbying, you still might be out on this one. So they just want to make sure that the lobbying entities don't get the PPP too. Also, some other ones is if you've got, there's some other ineligible ones, but more guidance is needed on this just to make sure that we understand it's 15% of gross receipts and what that calculation is. Also, it may be on your first draw that you may have to show that there's a decline of 25%. I've heard that from the AICPA with that caveat. We're still looking for guidance on that. I couldn't find a yes or no on that, but I put down even the rumors on this. So also back to the 501c6 organizations, the American Society for Association Executives and the AICPA are trying to get a lot more clarification. So you will get more clarification on the C6 entities. Okay, so gross receipts reduction of 25% or more. And that's with that PPP2 for sure for second draw. It appears to be based on the calendar quarter, not a 3-month period. So you have to take your calendar quarter on that. And also because it came out in 2020, it was written so that if you wanted to wait until 2021, which we're not getting guidance until now anyway, you can compare all of 2019 and all of 2020, which would be pretty easy to substantiate because you could just look at your tax returns as substantiation on that calculation. Okay, gross receipts. What is gross receipts? Basically, it's your usual stuff, but then also they want to specify that if you did get the PPP originally, do not include that in gross receipts if you have already recognized it as a contribution. So don't make sure you take that out of your gross receipts calculation and then look at the difference. So how much is this calculation? This calculation is 2.5 times the average monthly payroll for most organizations. Restaurants and hotels, they're saying 3.5 times the average monthly payroll. So the best way to do it is to take your average, your total payroll, divide it by the number of months, multiply it times 2.5. You can use either 2019, 2020, or any 12 months prior to the application for those payroll costs. If you're a seasonal organization, then it's a 12-week period, sometime in the February 15th to February 2019 to 2020. Now, that 12-week period, we cannot find that it has to be a calendar year. I think that calendar year was just for that 25% decline. And so I think that could be any 12-week period. Okay, so who is a seasonal employer? It operates in no more than 7 months in a year and earn no more than a third of its receipts in any 6 months in the prior year. Okay, the PPP second draw process, a little bit more about that. First of all, the lender will submit a request to increase the PPP loan through the SBA, and it cannot exceed the maximum loan amount, which is $10 million. Now, the PPP2 maximum is $2 million. I don't think we have anybody on this call that's right there at both of those maxes. The borrower must provide the lender with the required documentation to support the increase. Okay, who are the lenders in this case? You've still got the traditional one. So if you were satisfied with your lender, if you got the PPP original and you liked your lender, you like that relationship, then go ahead and use them again. If you didn't, there are a few alternatives out there now. There's some fintechs like PayPal, Intuit, that kind of thing, that are also qualified to give these loans. Covered period. It was during the PPP original, it was 8 weeks. And then the revision was 24 weeks and there was no in between. Now you pick your covered period. Okay. So you can choose between 8 and 24. And the PPP covered period is extended through March 31, 2021. Now, a little bit about that is you have 10 months after the end of your covered period to get forgiveness. If you have not applied for forgiveness in that 10 months, then you will start having a loan at that point. So you want to make sure you know what your covered period is and look at the last date and make sure you make a decision before then. Okay. If you refunded your first draw, you got a first draw out, you said, well, things are not that bad and let me give it back. You still can get some of this PPP2. However, the SBA has 17 days to give us guidance. So we do not have that right now. So the borrowers can also look if they had guidance that they were using for their original PPP and they did not get the maximum amount they could have when things changed. You know, there was that hustle at the beginning. Then you can go and look and talk to your lender and say, hey, this is the calculation we should have used, but this is the one we did and we could have gotten more money. What can we do? So look into that with your lender. Who is not eligible for the PPP2? First or second draw, businesses that weren't in operation before February 15th of 2020, shuttered venue operator entities or organizations. Now we're going to talk just a little bit more about that in a minute, but that's basically zoos, museums, and theaters, because there is a separate caveat for just those entities. And if you don't fit into that category, then you can look and see if you're eligible for this PPP2. Also, publicly traded businesses, okay, and other things is like businesses affiliated with the Republic of China. So there are some other organizations that aren't eligible. The loan forgivenesses, okay, it's the same as the PPP1. You're going to have payroll costs, and it's, they've defined what is payroll cost: group, life, disability, vision, dental insurance. You've got your mortgage, interest, rent, utility payments. Those were all the same. And there's still a 60-40 split. That was that second act that came out last year, 60-40 split between payroll and non-payroll for both first and second draws. So you need to have 60% of the total. It needs to be substantiating payroll expense. However, now we have new expenses. So if you have not gotten your forgiveness, you have an opportunity to look at other expenses for that 40% for your forgiveness. Some of the other expenses are the worker protection expenditures. So this is PPE, too many PPs here, PPE cost to comply with COVID safety guidelines. And those are things like, oh, you had to get a drive-through window, you needed a new ventilation, you bought filters, you bought, you bought some HEPA filters throughout, you got the temperature screening things, you got all the sneeze guards that are everywhere. You had to buy all of that. That is eligible as an expense to go for your forgiveness calculation. Another thing is supplier costs. So it's expenditures to get suppliers to keep your current operation. So maybe your supplier that you were using had some issues and they had to shut down, and you had to get another supplier, and there was more cost with that. So that's sort of vague, and I'm hoping we'll get more guidance on that. Another couple of expenses is operations expenditures. So Zoom accounts, cloud-based computing, software, HR accounting, some other things that, maybe you had to hire somebody just to deal with people getting COVID and dealing with all the rules with that, or you've had to have some outsourced expenses with that. And then finally, property damage costs. And this was related to the 2020 public disturbances, is what they're calling them, not covered by insurance or other compensation. So if you were damaged in any of the protests, then that could be also an expense that could go on your PPP. And again, that's just the 40%. The 60% is the payroll. Okay, there is a simplified loan forgiveness for loans of $150,000 or less. And the SBA has 24 days to give us guidance as in an application. So we want to make sure to look for that at the end of January, another week or two. It's going to be a one-page, and it's going to have an attestation that, yes, you did have a need for it. It's going to show your loan amount, the number of employees retained, the estimated of the loan amount that went towards your payroll costs. So it's just a lot of things that you had at the beginning when you were applying. And your loss of revenue, you're going to have to substantiate that also. Okay, a big thing in this is that the PPP funded expenses are now going to be deductible. So almost all of last year, after the PPP got going, everybody got the PPP and they got the money. They were happy. And then all of a sudden, the IRS said, wait a minute, you can't deduct those expenses. And so everyone was scrambling. The for-profits were scrambling. Not-for-profits, not so much. This only relates if you have UBI and you have some of the payroll costs that are offsetting your UBI income. So that's the only reason that would affect you. So, but they're now deductible, so it doesn't, and it's going to apply for PPP2 also. The EDL advanced grants. Okay, this is this grant portion. So you applied for the EDL grant or application of a loan, and you got this advance grant at the beginning, and it was a certain amount times your number of employees, like 1,000 per employees, and it was up to $10,000. And the IRS said, wait a minute, that goes against your PPP forgiveness. Now they reversed that and they said, no, it doesn't. And so if you had an EDL grant and the PPP and the grant portion was offset against your forgiveness, and so you had a calculation to do for the forgiveness and you've already applied for that, you can retroactively go back and revise that again, we don't have guidance on exactly how that's going to work, but we should get that in the next month. So it's going to require a little bit of cleanup. Okay, I know we were a little bit behind on the keywords. Ken, do we have another keyword?
Yeah, Fran, the last keyword for the CPE credit today is stimulus. So we've got our new stimulus package. So stimulus is the third and final keyword.
And do we have any questions at this point that you haven't answered?
No, I've been, and so if you do have a question, put that in the question and answer feature and, in Zoom here, and I'm monitoring that and answering a few questions on the fly, but I think we're okay, Fran.
Okay. Okay, that gave me a chance to get some water.
Glad to get over.
We have a few more provisions to go through. So I'm not going to talk about this much except for the shuttered venue operators. So the biggest question we have on that right now is when they will become available. We do not know. We haven't heard anything yet about when you can apply for them. So you must have like 3 characteristics for this shuttered venue. First of all, to impose a cover charge through ticketing or a door charge. Second, performers must be paid in an amount that is, hold on just a second, paid in an amount that is based on the percentage of sales, a guarantee or another mutually beneficial formal agreement, and not less than 70% of earned revenue is generated from the sale of beverages, food, merchandise, or other nonprofit educational initiatives. So those are really quick and dirty. Yeah, that's there's real specific. And then you have 7 requirements for the businesses. The biggest one that I'm seeing, hold on just a second. The biggest one I'm seeing is that the revenue has to be less than 75% of the same quarter in 2019. So that is huge right now. Okay, the employee retention tax credit. Hang on to your hats. This one is big. So this one, originally I had slides. This was from the July presentation. And I have slides and I've labeled them the CARES Act up here. So this, I just slid in the slides from that presentation. And so basically you could not do this. This was a calculation to get a credit for employees that you were retaining, whether or not they were working, but you were paying them. And basically the IRS said on this, there was a lot of information there, that the credit was not available to those that were doing the PPP. So with that, you can't, we were stuck. If you were doing the PPP, you could not do this ERC. Now with the Consolidation Act that we just had signed, they're saying all of that is not quite the same, okay? And this is where it gets really confusing. Now with the Consolidated Appropriations Act, it is available to those recipients of PPP. Now they have a different calculation, and this is the hard thing. It is now extended. It did cut off at 12/31/2020, but now it's extended to July 31st. The credit is increased from 50% to 70%. The maximum amount per employee used to be $10,000 total. Now it's $10,000 per quarter. There is a decrease in the reduction of gross receipts. It used to be 50%, now it's 20%. And then the definition of a large employer was 500 and now it's 100. Now, the problem with this is that this is retroactive, but it's not. Okay, so if you got the PPP, you can go back and look at last year's wages and see if you want to calculate this to see if it can work or not, but you have to use last year's numbers. So don't use the new and improved numbers that they just came out with. You have to use last year's numbers for the PPP, for the ERC. This time on January 1 in 2021, you can use the new numbers. So how does that work? Okay, so you want to look at the eligibility and go back and say, okay, could I have gotten this except I had the PPP? If it's yes, then go back to the CARES Act, look at those percentages. I just had those on those slides to begin with, and use those original percentages. Then as of January 1, use the new percentages in the Consolidation Act. So let's see, I'll go through a quick example because this is really confusing. So you have 3 employees, and I've put their amounts that they're paid in quarter 2, 3, and 4 for 2020. Okay, so how would you calculate this? In quarter 2, the first employee, $6,000. That's under the $10,000 threshold. Yes, that's eligible. The second employee, they had $12,000. Only $10,000 is eligible. The third employee, $8,000. That's all eligible. The third quarter, well, the total amount of employee A, yes, it's includable. Employee B, no, they used up their $10,000 max for the total year in quarter 2. So they don't get anything in quarter 3 or 4. And then finally, the C employee, instead of having 3,000, only 2,000 was eligible, and then they're maxed out at the 10,000. And then quarter 4, the only one that still had any remaining amount for that 10,000 per employee was A. So the total amount, if you add up all of those totals that are eligible, then that's $30,000 times 50%, which is the total in the CARES Act. That was the total for 2020. Now you can look at 2021, and it starts over at a new year. You've got new totals. So quarter 2, they get everything for each employee. And I've got a typo on that, and it should be quarter 1. They've got everything. And then quarter 2, they've got all for the employee A. Employee B is still maxed out at 10. It's 10 per quarter instead of 10 for the total year. And then employee C is 8,000. So their total amount is 48,000 times the new percentage in 2021, which is 70%. So it's a credit of 33,600. Now, how do you get this credit? It is not a credit against income. It's a credit against payroll tax, which is something that nonprofits all have if you have employees. So it is great. Now, if you, in 2021, if you need an advance on it, say your credit is higher than your payroll taxes in the first quarter, then you can apply for that credit on Form 7200 and get an advance. And then when you do your 941 at the end of the year, there's a true up and a reconciliation. That's not available in 2020. Hopefully, you might have to do an amended 941 if your payroll provider or you have already done your 941 for the year. So I hope that's clear. It took us a while to figure all of that out, but the retroactive portion is only because you had a PPP in 2020. Now you become eligible, but you have to use all the same percentages from 2020. Okay, a few other things. I'm not going to go through those. You can read the slide. Yes, we're getting stimulus checks. That's the amounts. There are phase outs on that, and they go really fast because the stimulus amount is smaller. A couple of things that are nonprofit oriented is the $300 above the line charitable deduction that happened in the CARES Act. The Consolidated Appropriations Act has the same $300 per individual, but if you're married filing jointly, you get a total of $600 to max out. Whereas in 2020, you didn't. This would be for 2021. The CARES Act, they also did away with the modification on the limitations on the charitable contributions, and the Appropriations Act extends that for another year. Retirement accounts. The CARES Act said no RMD for 2020. Well, the Consolidated Appropriations Act says, nope, it's back. The big thing is the balances are probably going to be bigger this year because they didn't take anything out last year and the stock market is doing well. So There is some area to do some tax planning to make sure that your donors know that you can get a qualified charitable distribution through their IRA going straight to the charitable organization, and they're not taxed on that. So they don't have to worry about trying to itemize, and it's not included in their income. Taxpayer First Act, this is a slide that I had in the July statement. And this was just talking about e-filing for the 990s. It's coming. It's here for calendar year 2020. And we have a new form. It's a 990T. It's a new form because everybody, they just issued the final act on the silos. They're here to stay. And so this is a new form. And right now it's draft form on the IRS website. I'll be updating that soon as soon as they come out with one. I'm thinking it's going to be e-file because that was their whole mandate, is they were trying to do an e-file. So it's a 2-pager. It will have schedules attached to it where you actually calculate all of your UBI different areas, and then this is the total for that. Whew. Okay, I'm done. I know I sort of glossed over a lot on that, but there is so much. The act, the $900 billion stimulus act is 5,500 pages, and there's a lot of information in it. If you've got any questions, please reach out to us. I know that this is very confusing, and if you need more clarification, just reach out to us.
Yeah, thank you, Fran, and certainly appreciate you trying to take in all this stuff over the last few days. It's pretty overwhelming. There's as Fran had mentioned, I mean, there's new guidance coming out on this all the time. I love the way they call them interim final rules, which means these are the rules now until we change the rules next week. And so hang on tight. I think this is going to be a continuously developing act in terms of the guidance that comes out. And so please reach out to us with questions that you have, and we're glad to assist as we can. So